So, in the last class, we have discussed till section 155 to 157. And under the provided section, we have discussed about the mixing of the goods. Under that, we have discussed in the details that when the goods has been mixed with the consent of the buyer or without the consent of the buyer, then what is the consequences in this? This is what we have discussed in the last class. Okay. So, providing the summary regarding the latest session we have discussed. Under section 155, we have discussed when the goods are mixed with the consent of the buyer, then the buyer and the belly share the mixture based on their proportion. For example, uh, there is the consent of the buyer to mix her or his own goods with the goods of the belly. Okay. For example, there is 15 kg of the rice that is at the belly's house. Okay. The beller is coming to the belly and asking the belly to keep his own rice at belly's place. Okay. And it is the given consent by the beller to mix the rice of the beller with the rice of the belly. The beller who is bringing rice to the house of the belly, that is up to the amount of the 5 kg. But previously, the belly has 10 kg of rice at his home before ahead. So when the beller is coming to the belly and giving his consent to mix up the amount of the rice with the rice of the belly is mixing the things and keeping it with a proper protection. So when it comes about taking back the things, the beller is responsible or liable to get up to the amount of the 5 kg of the rice only, because there was the 10 kg of the rice before. The beller provided 5 kg of the rice. So the previously given 10 kg plus the given 5 kg rice of the beller, it produced 15 kg of the rice in all total. And it has already been mixed together. It is unable to separate the rice of the beller from the rice of the belly. So, in that specific circumstances, this is the duty or this is the responsibility of the beller to get back the specific proportion of the amount which he has given. For example, if the beller has given the 5 kg amount of the rice, then he has to take back that specific amount of the rice only. That means if the amount of the rice is 5 kg that beller has given to the belly, then beller is responsible to take back the amount of 5 kg of the rice from the belly. It cannot be specified that the beller is responsible to take the rice which he has provided to belly. It is not mandatory because the rice has already been mixed up. It is unable to separate the previous thing from the new one, right? So, from the mixed product, the beller is liable or responsible to get the specific amount which he deserves according to his proportion. According to his proportion, he has provided 5 kg and the belly had 10 kg. So here the proportion is 1 is to 2. So here, if the whole amount of the rice will be divided in 3 parts, the baler is responsible to get 1 part of the rice, and the rest 2 part of the rice will be given to the belly. Got it? Then comes the mixing of the goods without beller's consent. So when we are talking about the beller's consent is not there. Okay. So what will happen in that situation? If the goods are mixed without the consent but can be separated, the belly must bear the cost and any damage occurred. As cotton bales are mixed with bees, and B must separate them and pay them for the damages. Okay. So, what does it mean? It means when we are talking about the consent of the baler, in the first thing, there is the clear consent of the baler on that specific act under section 155. But in the second case, there is no consent of the baler to provide the goods. Okay. So when there is the absence of the consent of the baler, if the goods are mixed without consent but can be separated, but the belly must bear the cost or any damage that has been occurred. Okay. According to section 156, okay, when the goods are mixed without the consent of the bearer, then what will happen in that case? Okay, if the goods are made without mixed without consent, but the goods can be separated, then the belly must bear the cost and any damage that caused. Okay. Okay, so let me give you an example of this. For example, I am the beller and you are the belly. Okay, I have given you up my certain things which you have kept keeping it carefully to keep it carefully or to take care of it. Okay, but unfortunately, my goods has been mixed with your goods. It can be separated, but when we are talking about the uh, cause of the mixture, okay, it can be separated, but when we are talking about the cause of the separation, cause of the mixture, then we got to know that the belly is definitely going to face certain kind of the difficulties and damages. Okay, so here, without the consent of the beller, if the goods are mixed without the consent but the goods can be separated, then in that specific cases, the belly must bear the cost or any kind of the damages that has been caused. Okay. So when we're talking about the if the goods are mixed without consent but can be separated, the belly must bear the cost and any damages occurred. Okay. Then comes section 157, which speaks about when the mixture of the goods cannot be separated from each other, when it is closely attached with each other, or when it is unable to be get separated from each other. What will happen there? If the goods cannot be separated, the belly must compensate the bearer for the losses or the damages. The answer is very simple, that if the goods of the belly cannot be separated, okay, then the belly must compensate the bearer and the bearer for the loss. Okay, that means if the goods cannot be separated, if it is a situation where the mixture has already been happened and it is seen that it is impossible to derive the mixtures, it is impossible to separate the mixtures of the goods, then in that specific case, if the belly is facing any kind of the problem, then the belly, if the beller faces any kind of the issues, then the belly must compensate the beller for the losses or the damages. So according to law, if the goods cannot be separated and the goods belongs to the beller, okay, so here the belly must compensate the beller for the losses and the damages. Okay. Then comes your section 158, which speaks about the necessary expenses. Okay. So when we're talking about the necessary expenses, If the belly is not paid for their work but incurs necessary expenses, the bailior must repay them. Example: A gives clothes to B for the free storage. B spends on pest control to protect them. And in these specific circumstances, it is the duty of the A to reimburse the B. Okay. So when we're talking about the necessary expenses, at least we know that the belly is not paid for the work but incurs the necessary expenses. Okay, the bailior must repay them. Okay, and that is why A gives clothes to B for free storage. A spends on pest control to protect them, and A must reimburse B. Okay. Then when we're talking about section 159, we're talking about uh, the lender. We're talking about the return of the gratuitously lent goods. Okay. Section 158 we discussed about the necessary expenses, but section 159 we are discussing about the return of the gratuitously lent goods. Okay. So what is it? It is explained under section 159. Okay. Then first, let's have a conversation. When we are talking about section 158, which speaks about the necessary expenses. What are the necessary expenses on this? Okay.